Honorable Celeste Okore allowed the suspect's notice of motion dated 17th November 2025 in miscellaneous application number E1640 of 2025. Among the orders she issued was the requirement for the suspect to appear before the Ethics and Anti-Corruption Commission on 18th November 2025 to have his statement recorded. On 25th November 2025, parties appeared before me, and following lengthy submissions, this court restated my sister's orders by directing that the suspect to present himself to the KCSE officers to record his statement and for processing as directed. The matter was then fixed for mention on 2nd December 2025 for further directions. When parties appeared before me on that day, that is on 2nd December 2025, the defense counsel confirmed from the bar that the suspect and his counsel indeed presented themselves at the KCSE officers by the investigation officer and blatantly refused to record his statement as ordered by the court. He then went ahead to seek orders that in this matter be deferred until such a time that the KCSE will have complied with the orders of the court. He further prayed that the terms of the suspect's release of personal bond 500,000 be extended pending plea-taking. The defense counsel also disclosed that they have written a letter to the DPP in which they have listed 10 points that they wanted the DPP to address before the suspect hearing can take place. In his response, Mr. Bore, the prosecution counsel, informed the court again from the bar that they have complied with the orders of this court, in that they already amended the charge sheets as proposed by the defense, and that the suspect hearing was cautioned and processed. He further submitted that on 25th November 2025, there was new information that came out after delivered my ruling. The new information was that the suspect's statement had already been recorded. He submitted that since the orders did not specify whether or not he was to record a fresh statement, the investigating officers cautioned the process and cautioned and processed him by taking his fingerprints. He pointed out that the new information had not been brought to his attention at the time he was responding to the defense counsel's submissions on 25th November 2025. I have really considered the submissions by both sides. Right from the outset, I must emphasize that this court neither can nor should instruct an investigative agency on the manner in which to carry out its investigation. Such authority is granted to the Office of the Director of Public Prosecutions. These are cases where there is a charge sheet, and the prosecution wishes to have the suspect hearing and take a plea. If I comprehend their stance correctly, the investigations have concluded, which is the reason the charge sheets for both cases of both files were drafted and filed. However, the defense counsel has informed the court that he has written to the DPP and that in his letter, part of which he read out to this court, they have raised some issues, including issues which touch on the complaints they have raised before this court. Mr. Bure has acknowledged that indeed the same letter was received, but he needed time, at least a week, to seek directions from the DPP. Under Article 157 of the Constitution, the DPP can direct the Inspector General, and in this case, investigating agency, to investigate any information or allegation of criminal conduct, and the Inspector General shall comply with any such directions. Article 157(6) of the Constitution further lists the powers of the DPP, which are listed, replicated in the ruling. Indeed, it is accurate that Honorable Kore and this court directed that the suspect in this matter be afforded a chance to provide his statement. However, in light of the new information indicating that the relevant statement has already been recorded, it would be appropriate for this court to require that a statement be recorded prior to the suspect taking plea. Given that the prosecution counsel requested additional time to obtain further directions from the DPP, I'll leave that office to determine whether it is essential for the suspect to provide a further statement, considering that the court has been informed that he has already recorded 2 statements previously. Regardless of the directions provided by the DPP, the question of whether the suspect's statement was indeed recorded, as this court was informed from the back, will remain a matter for trial. Having said that, hereby I'll set this matter for plea-taking before the duty court on a date that we are going to set shortly. The terms of the suspect's release, as set by Honorable Court, shall however remain in force pending taking of the said plea. Those are the orders of the court.